Yeah, so I want to talk with you guys about disclosure and discovery. And I want to talk with you about that because I actually just had court this afternoon here in Phoenix, and we went, I went, and my clients and I were ready. And prior to it was a child support hearing. So we got an order from the court, a minute entry from the court, and it told us exactly what we had to bring. So some of the stuff that we were supposed to bring were an affidavit of financial information, the last 3 years of tax returns, the last 6 months of pay stubs, and the breakdown for health insurance costs. So there was a deadline to disclose all of this information, and we disclosed it by the deadline, which was last week. So, anyways, I was preparing over the weekend to go to the hearing, and I realized I had absolutely nothing from the other side, the mother. And my staff is really great because they put together everything for me. So I had nothing, and I showed up to the hearing thinking, I don't know what is going to happen here because I didn't feel prepared because I didn't have anything from the other side. I only had half of the equation and what my client was telling me. So we showed up, and the way that they do child support conferences here in Phoenix, when the state is involved, like when somebody's receiving public assistance, they have you meet with a conference officer first. And usually that person's a paralegal or it could be an attorney. And they sit with you and try to go through all the numbers. Well, the other side appeared by phone. So my client and I were there with the conference officer, and the other side still didn't have anything, and I didn't have anything in my possession. And so as we got to talking, I realized that I was never going to get anything from her if we had the hearing today, if we had the conference and the hearing today. She was saying that she had A, B, C, D, and XYZ to help support her case, but it wasn't in my fingers. It wasn't in my hands. I wasn't able to look at it. The representative from the state of Arizona actually had an affidavit of financial information from the other party, which nobody bothered giving to me, but it was from June of last year, so it was very outdated. And apparently in October, the other party had become unemployed. So it was not an updated affidavit of financial information. So what ended up happening is that hearing got continued. And that was after an hour of my traveling and getting ready for the hearing, and then my clients and I waiting for an hour, and then meeting with that conference officer for half hour. So it turned out to be a big waste of time. So to all of you, I want to stress the importance of disclosing all of the information that you're required to disclose. And you're going to find out what you need to disclose by looking in a couple of different places. The first place that you need to look is in the minute entries. A lot of times in their minute entries, the judges say that you need to provide XYZ to the other side. So do it, and do it on time. So in this particular case, the other side was really lucky, actually, I guess, because the hearing got continued. But there are some cases where the hearing proceeds and the judge says, guess what, other party, you're not going to get to provide, or you're not going to get to present any of your evidence because you haven't disclosed it in advance. And I've made that objection in a lot of trials where the other party shows up. They haven't provided me with information that they were supposed to. And I say, Judge, you need to keep this out of the evidence. They shouldn't be able to rely on this. And the judge has done it. So it was a pain for me and my client, but the other side, she really got lucky because she's getting a chance to get this information together and disclose it to us. Even if you don't know for sure that you're going to be using information, still disclose it. You can change your mind later. You don't need to use it. If you think that there's a chance, disclose it. I always err on the side of caution and disclose everything that I think perhaps I might use. The same goes for witnesses too. So you have to disclose your witnesses in advance of your hearing. And so you have to state their name, their contact information, and the substance of their testimony. So do that early, and update your list of witnesses as often as you need to. There are different rules that apply to expert witnesses. So if you have experts in your cases, like, a custody evaluation, somebody who did a custody evaluation, or a forensic accountant, or some sort of mental health professional, they're considered experts, and there are special rules. So you always have to look at the rules. And so that actually brings me around to the other place that you need to look to find out what you need to disclose. And that's your local rules, your statutes, your local statutes, the statutes in your jurisdictions. Look at the laws, and the laws will tell you what you need to disclose. So hopefully that makes sense.